Hey, how's it going, everybody? We're starting our governance study session. Hey, how's it going, John? Would you like to be on the web chat or the video? And who else is here? I guess we're the only ones here so far. Justin, if you're there, if you want to be on video. Okay. Man, I'm all stuck here by myself. So that's fine. We'll keep you. Let me see. Anybody else who wants to be on this video chat? I know we have a few people here right now. And let me remind the people in the Telegram chat to just try to bring people in here as well. So just maybe give me a couple minutes here. Just cut and paste this here. Okay. Let me see, what else? V2, the governance channel. Let me go to that. So let me see, who's here? Anybody who wants to be here on video with me? Hey, how's it going, Robert? Sorry, I was trying to message the Telegram channels to get people in here. We only have about a handful of people here right now, so it might be okay. In the meantime, anything you guys see out there in the governance channels in terms of news, anything interesting, I'll probably share a little bit as well of kind of maybe some of the things I've thought were kind of good resources to look for in some of these Telegram channels. So, and we'll probably start in a few minutes. I think Ville, who has been missing the last couple of weeks, said he might be able to join us, and so hopefully he could get on the web chat too. Hey, Robert, do you have a webcam? Sounds good, Matt. So Matt's just gonna be working in the background here. Otherwise, we just get started. Let me see. So yeah, okay. So in terms of kind of latest news or just anything interesting, I'll just go one by one. Jetse, I have to pronounce the name right, from EOS Amsterdam had some commentary about both versions of the Constitution. I thought, it was nice to kind of be able to go over kind of his document, and he's a lawyer from EOS Amsterdam, so I thought it was good that he made comments on both version 1 and version 2 of the Constitution. There was a message on EOS Alliance that showed some good activity in the Asian community, especially Chinese. It says that there are now 6 Chinese work groups that have formed outside the calls to discuss arbitration and governance. They believe free markets can support arbitration. They prefer no default arbitration. This is a summary by SpaceX. And SpaceX took a community poll, and 290 of 360 respondents believe users have the right to choose whether they should be subject to arbitration. So that's very significant. Just to catch you guys up, it seems, oh, hey, how's it going, Eddie? So it seems as though even you know, we did a poll in our very first study group session. Version 2 was already more popular. There was a recent poll in the Telegram channels, and it was pretty like, you know, it was like 60–70% that supported version 2. So it does seem to me that that's where, at least, you know, in terms of active participants, that's where, I mean, that's what people support, version 2 of the Constitution. At least, you know, those that are active on Telegram. We don't know necessarily about the whales or anything like that, but so 290 out of 360 in China, they did a poll, SpaceX group. That's 80% that support no default arbitration. So that to me is a clear signal that version 2 is far more popular at this point. Does anyone have any maybe objection to that, or what are your senses out there in the audience? If you can let me know if there's maybe a difference in a opinion or perspective about that. Yeah. Okay. John confirms that. We have one person. Anybody else? Okay. So those are the pieces of news. I also want to mention, just had lunch with a Chinese friend. Is he involved in any governance study groups, John, or is he just a token holder? Okay, so let me know. And I don't know, Ian, if you're there, I see you just kind of popped in here. We were just talking about version 2 being the kind of the consensus out in the Telegram right now, or at least the active Telegram participants. But maybe if you have an opinion, if you want to get on video, let me know as well. I could bring you in. So we just feel free to, you know, write something in the chat if you want to kind of discuss that. And so, yeah, the idea was just really to kind of review version 1, version 2, kind of at a high level, and then talk about version 3 at a high level. And if we have time, we can really dig into just start drafting a version 3 if, you know, there's interest in that. I feel like, you know, we can get started. I feel comfortable doing that, but it's up to you guys. So any other comments, questions? I feel like I'm talking to myself. So, oh, and one last thing in terms of news. Thomas Cox has a link that's called that he asked people, hey, did people sounds good, Ian. And I can invite you at any time. So Thomas Cox had this asked if people have read Calculus of Consent by James Buchanan. And I thought that was an interesting link. I think Buchanan was popular in the 80s and kind of influenced, you know, the Thatcher administration and the Reagan administration, if I'm not mistaken. And it was kind of the idea that, you know, you could get you know, efficient public policy, and I think that was the idea of the time, you know, just to use kind of the ideas that James Buchanan wrote about to implement that. So I think that's the case. I think I watched some kind of documentary. I did not read the book, but I'll give you the wiki link for that as well. I just thought it was a great resource, and so and Ian, if you want to kind of join, so yeah, let's review version 1 and version 2. It may be easier to just discuss the major differences in version 1 and version 2, and I'll just start with that if no one has any objections. So version 2 is all about intent of code is law. Bytemaster wrote a blog about it. Block One also has a good resource on their website. And essentially, it's the idea that they wanted to remove anything that was subjective and rely on code, right? And the intent of code as law. So version 1 had a lot of clauses that discussed maybe lying or vote buying and violence, right? And so version 2, because of the experience of what happened with the ECAF and the freezing and just realizing that that it was almost impossible to kind of prevent these and decide these cases, that it was better to kind of focus on just code as law. And so they Bytemaster Dan and Block 1 decided to remove a lot of the subjective articles from version 1. And the main 2 articles in version 2 kind of kind of specifies what they wanted to focus on, which is really code and code fixes rather than anything subjective, where you have to gather evidence. You need an arbitration of forum to our arbitrators to decide on cases where people would file a dispute, get evidence, and really go through the process of deciding which party to side with and give a monetary reward. So version 2 doesn't discuss any of that. There's no idea that anyone's going to have any restitution. At least it's not written in version 2, where people are going to get their money back if something goes wrong. It's really just about fixing the code. If something is actually is wrong, that there will be a way to update and fix the code. And it doesn't say anything about monetary restitution for any failure in code, right? So so that's the idea. So and the other articles in version 2, aside from 1 and 2, I should probably put a link there just so that you guys have can follow along. And actually, I'm gonna give you a link that has both versions on a Google Doc, so you could follow along there. And if you look at if you guys go to the Google Doc, if anyone's there, please click on the link. I don't see anybody else kind of getting on the link, but that has version 2 and version 1. And essentially the 2 first articles of version 2 are what I would say is the meat of version 2. And I'll probably just read it if no one objects. Okay, so version 2, Article 1, if there is a dispute on intent of code, then intent shall be determined by a supermajority vote of elected producers or an arbiter mutually agreed to by the parties to the dispute and enacted by producers. A supermajority may, at their discretion, freeze a contract during an active dispute until such time as code to fix the contract is available. The parties to the dispute must produce proposed replacement code. The producers may charge a reasonable fee or place other reasonable requirements on the parties to the dispute. A supermajority is defined as two-thirds plus 1 block producers. Ricardian contractual terms that cannot be enforced by properly functioning code are beyond the scope of the producer's authority to evaluate and enforce. And I think that last sentence is very important. Ricardian contractual terms that cannot be enforced by properly functioning code are beyond the scope of the producer's authority to evaluate and enforce. So essentially anything outside of this Ricardian contract, this it says, hey, we're not block producers aren't going to deal with it. So it's really just a matter of code fixes, and it gives kind of the process to make those fixes, right? You could freeze, but you have to have a replacement code, and you have to produce it, and before they do anything. And it's 2/3 plus 1, and that's pretty much it. So any questions about that real quick? Oh, hey, Ian, sure, I'll invite you. So I just invited you. Okay, so Eddie's listening from afar. Okay, Tanish, do you want to also be invited? Okay. So I'm gonna also invite Tanish. Hey, how's it going, Ian?
Hey there.
And sorry about that, I was muted. But yeah, excited to have you here, Ian. Really appreciate it. And we also invited Tanish, so hopefully he'll get on as well. So, but yeah, we just I don't know if you were here. I just kind of read Article 1 of version 2, and
yes,
yeah.
I heard that, and I would pose a thought experiment, if you like. Does the Constitution enforce itself? If you look at that clause, and as you said, the important part might be that last statement. What happens if there's a dispute about the Constitution? Does the Constitution provide for dispute resolution over itself, and therefore enforcement over itself? That's the first question. And if it doesn't, then what's happening with somebody who breaks the rules of the Constitution? What happens if the block producers decline to enforce Section 2? Does that mean that they get away with it?
Yeah, so first, Tanish is going to be on audio, I guess. So yeah, I guess we'll kind of have that question to the audience, and then I can respond, at least from my perspective. So yes, I would say that the Constitution really is, I mean, ultimately the vote of the token holders dictates how to enforce, who the block producers are, or actually decides who the block producers are. So ultimately the Constitution gives power to arbitrate to the block producers, but ultimately the block producers are voted in by referenda. So ultimately the power is still in the token holder. So delegated proof of stake is the ultimate check on what happens if someone defies the Constitution. So the block producers are just delegated some authority temporarily whenever they're elected as the top 21. Once they're outside of that, they have no power, right? So essentially, it's just a way to provide an additional check on the powers of the block producers, really, at this point. If in version 2, without any other entity or party, or because in version 1 there was an extra entity, the ECAF, which also in this one is not there. But even if if it was, it would be the same thing where token holders ultimately have the power, right? So they can remove this article in the Constitution, and they can change the nature of how block producers are supposed to act. And ultimately, if any party or any entity does not act appropriately, token holders can ultimately decide. So that's how I would answer that. So.
Yeah, but as we're seeing now, there's gathering evidence that the community isn't really having an effect on the block producers. And there is now a theory, conspiracy theory, if you like, or there's some evidence out there that suggests this, that the block producers have cartelized or have operated some group, and now the block producers are in control of the chain, which is to say they are moving the votes around to suit themselves, and the community itself hasn't got the voice that, in theory, we thought it would have. Now, we don't know if this is true or not, absent some process of proving anything, but it does seem reasonable to suppose that a bunch of whales could get together and just control the whole lot. So what is the point in standing on this notion that the community can control threats to the Constitution if, in fact, the community does not do that? Shouldn't we be putting more weaponry in there? And this was the thoughts behind the move forward from the original notion of DPoS that came out of BitShares and Steemit and so forth. We knew that the block producers had substantial power. They have the power to do anything, in effect. They can allow a dodgy transaction in and it carries on. So ECAF, or the concept of dispute resolution, was to take away the power of judgment from them. Not the power of enforcement, but the power of judgment. So now the total power is split into two places, ECAF and the block producers. Now, this is, if you like, decentralization of power in some sense or other. Now, if we fold that back in, which is what this proposal from Dan says we're going to do, we're back to the situation where the block producers have all the power. And is that what we want? Because I don't think that the block producers have as yet made the case that they're good guardians of that power.
So if anyone wants to respond, and then I can probably respond as well if no one else. So Ray says, well said.
Who's that we're looking at?
Ville, do you want to respond to this?
Hello. Can you hear me?
Yes, we can hear you.
Okay. I can't hear you very well because I just came out from an airplane and I'm a bit sick. so I shout a lot. Sorry about that. But yeah, about the block producer power. I think it's kind of vital to keep block producers as the executive and enforcing branch, and then having this all kind of arbitration and other things on top of that. So because in the last meeting that I was on, we were who will enforce if, or was that even one meeting before that? Anyway, we were thinking who will enforce society like this without block producers, and I took an example of current enforcing, which is basically that police will knock your door, or if that's not enough, then army. So we need some entity to execute and enforce.
So Ville has been missing this couple of weeks because we've been, at least the conversations that I, in my perspective, have shifted towards more closer to version 2, which essentially removes that arbitration form and layer. And I would say that one of the reasons is that we're ultimately, token holders have the ultimate power, right? So if whales take over the chain, that's the nature of delegated proof of stake and proof of stake, right? It's like, the token value should decrease because if there's any malicious activity going on, you really can't help it. It's their activities are hurting the chain, but it's hurting their value. So the foundation of that is that if they're not acting in the best interest of the blockchain, their value should decrease, and that should be the main incentive we should rely on. So I do understand that there's kind of this perceived power with the block producers. And a check on that could help that. But since ultimately the ultimate power is in the token holders, by adding an extra layer that also doesn't have, even with referenda, you're also as a token holder having to manage an extra entity. But ultimately, practically speaking, block producers are the ones that actually have to enact these. And so having the focus on just the block producers and almost having it as limited as possible, the scope as narrow as possible, you're making the decision for token holders at least easier. And because now, instead of having the arbitrators that don't really have, they only can kind of really have an opinion, and then you have to focus on block producers if they're the decision between, are they upholding this opinion from the arbitrators, but ultimately they can or they can't, and you kind of have to decide. So it adds an extra layer that is not as practical, in my opinion, when you add that. And then there's many other kind of maybe objections about like just even practically how that is. But just overall, that's my main case against having any third layer, at least at the base layer. And anyway, so and also, Ian, if you've seen the statistics, if you look at the Chinese working groups, and SpaceX did that, and I just read it. It was like 209. What is it? 290 out of. Let me read this. 290 out of 360 believe that users have the right to choose whether they should be subject to arbitration. So that, to me, suggests that they don't want base layer arbitration. That was the second point that they had in that. So it does seem to me that it's almost, at least on the Telegram channels, a consensus forming around the idea, in a supermajority forming around that idea. I don't know about the whales.
So the interesting thing about that is the question isn't quite right. You frame these questions and you get into trouble. If you don't have arbitration at the base layer, that means you have national courts. If you have national courts, you don't have any particular national court, you have all of them. So arbitration, if you like, is a great tool to defend against national courts. So if you and I are doing a deal on the chain and we get into strife and we decide to go into dispute, our only choice is to go to national courts. Now, you go to your national court, I go to my national court. I don't know where you are, but you're not in my national court, I'm guessing. And you don't know where I am. So we're in two different national courts. Now, that's actually a very difficult situation. Either a vast majority of people will never get the protection of national courts, or a small group of people will batter their way through national courts and cause confusion. Whereas arbitration creates that one single layer that homogenizes all dispute resolution into our own community, into our own space. So it resolves uncertainty in that respect. Now, is that a good thing or is that a bad thing? Well, it depends. For every case that's filed, there's somebody who believes there's a dispute, and that person believes they're right, and the other person believes that they're wrong, presumably. Now, are we saying that we don't want to give people the chance to be right and be proven right? It does seem kind of harsh to say, the blockchain is a place where you get to be proven wrong. You get to be proven that you've had stuff stolen from you and there's no recourse. It seems very antithetical to say that we're creating a community for the future where everybody can be treated equally badly. So I don't know. Now coming back to your other question about the Telegram groups. Yeah, there are distinct groups of people out there. Eve spent some time in China and he spoke to a lot of people. And he came back and he said, universally, people in China and Korea want arbitration. Now, that's an opposite viewpoint. Universally, as far as we know, the whales want arbitration. And the reason is, if the whales get robbed, what next?
Oh, yeah, yeah, but I think that the base argument from the non-base arbitration people is that people would eventually anyway end up with arbitration agreements. I haven't decided yet my stance on the base layer arbitration per se, but I have understood that the people who are opposing base layer arbitration are saying that people will end up anyway to arbitration agreements between themselves because it's practical. So at least that's how I have understood it.
Just having a bit of dinner here. Right. So one of the things that you have to consider is, what are the nature of the cases that we are deciding to resolve in arbitration? And right now, probably the majority are straightforward theft of value. Now, in that case, is the thief going to be likely to agree to arbitration? And the answer is probably not. We can probably agree that the thief will say, no, I'm busy stealing. So if we think we want to cover the case of straightforward theft, then we probably have to impose arbitration at 100% level at the base layer. And it has to be imposed in the contract, the constitution, on entry to the chain, so that the thief is also under arbitration.
Well, in case of thefts, we have this problem that we are really in the realm of contract law. You could still, for example, if all three of us have some sort of accounts, and I steal from both of you guys, then of course with the current constitution, there have been breach in contract, okay? But you can still file a criminal report against me. So then there is overlap. And
overlap into the criminal domain is what you're saying. But let me just post the Constitution for you. The Constitution grants the rights for property.
Oh yeah, but this doesn't really take any stance on the fact that if I do something criminal, which your jurisdictions think that is criminal, then you can start independent processes against me.
Yeah, but I don't care. What you've done is you've breached the Constitution. My Constitution, which is a contract, gives me the right to my property. Or literally, you give me the right to my property. The members grant the right of contract and private property to each other. If somebody comes along and abuses that right, that's a contractual dispute. It may also be a crime. But it's a contractual.
So that's why I said right away that that's a breach of the contract. But at the same time, that's under criminal law. So it would anyway. For example, if I steal 1 million from you, you anyway would be interested of criminal criminal consequences. So I don't really, but as said, I don't really have stance on base layer arbitration yet. But this is just some as objective as possible ideas around the problems.
Yeah. So the issue is, let's ask, what are we trying to do? And one of the things that we were trying to do was basically build a blockchain for small business. And the theory is small business doesn't want to invest in blockchain because it's too dangerous. Okay, so let's make it less dangerous. One way to make it less dangerous is to allow restitution of damages. And this more or less on paper achieves it. We haven't achieved it in practicality yet because no ruling has been issued, but maybe that'll happen soon enough. So the question then is, why are we going back from this situation? You know, why don't we want to give small businesses the safety of a safe blockchain, their ability to get restitution for serious harms? It's a question. Don't we want a blockchain that's successful?
Here I can put my code is law hat on because I have been Ethereum developer since 2016 spring. So I think that blockchain gives us possibilities that we can't really use yet, and I think that kind of global trustless commerce is one of those, and when there are more layers on that, then the trustless commerce will be less trustless commerce. So I appreciate that EOS is easier to govern than Ethereum or Bitcoin. The processes in each of these chains are kind of random. Some changes happen here in the code. 10 miners will add up if they will. So I appreciate that EOS makes processes for governance, but still I think that we have to keep in mind that we code is law hippies think that the trustless international commerce will give us options that we don't know yet how to use.
But you seem to be agreeing that code is law isn't really working very well yet. And we have to, what, try harder? Lose more money? How long do we go on with this for? It's been a decade. It has been a decade.
Well, okay, yeah, that's fair point. but I think that people should write better code. But yeah, I agree that there must be some middle ground. and
better code. Better code. How long have we been in the software industry? 70 years, and one thing we've learned: we can't write better code.
Yeah. Perfect code is quite hard. but yeah.
So I'll chime in here just to also put in give some input to kind of your questions, Ian. So I think the first thing, well, just start with the most recent, I guess issue, which is theft, right? And I think Ville mentioned, we're in this is a contract, and by having more of these criminal issues, there's really no dispute. There's no counterparty to kind of theft, right? So no, practically speaking, this is outside the scope of a traditional contract where you have counterparties. You can possibly, like you say, okay, you're agreeing to these terms of the Constitution, but just by using the blockchain, if you're being very broad. But it's really actually a pretty weak argument that any of these articles are enforceable as a contract. That's already, I think, is going to be a weak case in front of traditional arbitrators or courts or whatever. So the idea that this is a contract and people are kind of obligated to kind of abide by this as a contract, especially when thieves are just going to be outside, they're not going to care. They're going to just hack or steal regardless. That there's going to be no really standing for anybody to declare that they're under this more broader criminal law jurisdiction or even civil. But regardless, if there is no counterparty to a contract, which I would argue that it's going to be hard to make a case that this is an actual contract. It's well, anyways, I'll explain that part later, but it's outside traditional scope of contract law that you have these criminal issues that are stated within a contract is from, at least from my understanding. You might be able to say what you said, but so that's one. If you want to respond to that, Ian, I'll go ahead, and then I'll also address your very first point as well, if you want, which is about jurisdiction.
you're putting a label. You're putting a label on there and saying, therefore, we brought in that whole criminal aspect. But no, the Constitution stands by itself. It creates property. Now, if the counterparty, who does exist, because we know that they have done something, does not come forth, that's normal in the case of all disputes. The arbitration forums, the courts, they all know how to deal with a counterparty that does not come forth. The case is prejudiced against them. That's very simple. Now, why is this a contractual issue? Because there are very clearly identified damages. There is a contract. The Constitution is a contract. You could conceivably say, right, because you could say, for example, this is a criminal matter and therefore the thief could go to national court and overturn the ruling because it's not based on criminal law and the arbitration doesn't have jurisdiction over that. You know what? That's a risk we can take, I think. We can accept the risk that this particular case against a thief is overturned in national courts.
Yeah, so, and then I'll discuss about national courts too, because that was the very first question. And then Ville, you could go ahead. So I do understand that I like the idea of arbitration in general. The Untitled makes sense, right? And so the idea that we can find a way to resolve issues internally so that we don't have to rely on external courts is great. And if we're able to somehow abide by Untitled kind of agreements, that's fantastic. But if we don't need to have an arbitration layer kind of at the base layer to achieve that. You can have arbitration at the at another kind of at the DAP layer. And the other reason is, regardless of if courts try to intervene, we have a blockchain, and that's really the power of blockchains, to be in a sovereign space where courts really can't really do anything. And they haven't done anything really. They may in the future, but with delegated proof of stake, if they try to go after block producers for anything, you can actually just vote them out. And so that's the ultimate protection. So we shouldn't forget that the ultimate protection against external intervention from governments and courts. And I do agree that we should go through this arbitration like at the DAP layer, but the idea that we're somehow vulnerable is, to me, kind of goes against the powers of the blockchain. We have the sovereign space. We can vote block producers out if they get subpoenaed by the courts, if they get somehow courts have to intervene there. So that's one point I want to make. So it's not, I would say.
Yeah, but you know, that point doesn't work very well because we don't have the power of the blockchain. The top 21 or so, whales or BPs or whatever, are in control. And
yes,
right.
and that's again, that's really the ultimate reality of proof of stake. The token holders rule the chain, but that's really what I think people understand and accept, that the idea that one token equals one vote is the fundamental power behind this entire system. And if the economic incentives for that doesn't work, it's just the actual concept of proof of stake is no good if that's the case. And I don't believe that's the case. So.
Well, you know, the power is only good if the power delivers something of value. Now, the question is going to be, are we comfortable with the notion that 21 block producers or whales or whoever they are can control the chain? Are we going to be attracted to come in and invest in that chain, knowing that we'll never have a voice?
Yeah, so go ahead, Ville. But no, Ian. So, I mean, go ahead, Ville. I'll let you go first.
Okay. I have to return to a couple of points here about the contract itself. In fact, yesterday in London, I met Eve, and we returned to this same issue, that do we have a contract? And then we were discussing from both sides that do we have a contract or don't we have a contract? It's because I think that there are solid arguments both ways. Like you could say that, of course, we have a contract because all the transactions lead to the constitution, the tapos way, and then you can say that, well, of course, we don't have a contract because it's not provided to the user, and then you can say that, well, ignorance is never basis in court, that I didn't know this, and then the other side can say that, well, it's not presented still. So
yeah. So the question is, have you agreed to the contract?
Do we have a contract?
Now, yeah. Have you agreed to the contract is a defense. You can go into an arbitration and you can say, I did not agree to this contract. Or you can go to a court and you can say, I did not agree to this contract. Now, the response to that is very clear. Okay, show us your contract.
Yep.
If you don't agree with the Constitution as being your contract, or you say you never agreed to it, what's the alternative you're putting on the table?
Yeah, that would be interesting. So who's up to try this on court? Let's have a civil case on this on some court.
Yeah, and
well, it's a very easy result because you haven't got an alternative document. So the next question is, what is your claim? Your claim is you lost some EOS, or you own some EOS, or you moved some EOS and it disappeared or something like that. But you don't have a contract which establishes your EOS. So you don't have EOS. You don't have a claim.
Yeah, but I think that here, of course, I think that when I start to interact with the token, I automatically come as a party of the contract. But still, because that contract is not provided anywhere, it's just like implicit. So that's.
It's just implicit. That's right. What about the code? Is that just implicit?
It's not. Yeah, yeah. That's a good question. It's
the code and the contract are both difficult to interpret and present to the user. Yep. Now, if you're making the case that the contract, the Constitution was not presented to you, therefore it's not a valid Constitution, you're also making the case that the code wasn't valid.
Okay.
And you're now making the case that it doesn't exist. Nothing is valid. So we're fine with that. We've got your EOS, and you've got something that isn't valid.
Yeah.
That's fine.
Yeah, well, I have to think about that when
yeah. The thing is, the Constitution establishes your rights to EOS, and therefore the Constitution has to be agreed to if you want your EOS.
I would disagree, Ian, with that, because really right now, when you intervene and actually claim property somehow as an external entity or whatever this is that claims the right to these tokens, I would say where does that what would that say about the token holders that exist today that will somehow believe that there's this another authority or kind of collective or whatever that owns this property of yours, which you have the keys to, right? So to me, that would be kind of antithetical to the idea of people owning cryptocurrencies, and the idea that the Constitution can somehow create these property rights by fiat, by saying, hey, this is the way it is. I think without especially, I mean, it would have to be by referendum. Even by referendum, I would argue that would be illegitimate, because you're essentially putting this new claim on property that never existed, and in an abstract collective or body that also does not exist, right? So anyway, so to me, if whatever you write in the Constitution, it could be challenged, and will be challenged specifically if you write that these are property rights that are created if you deem it so, even in the Constitution. So I would be careful about writing anything about like this new property right that's created in the system. You probably have to create, yeah. So
I will just say one more thing. If you go to look at all the court cases about crypto, the courts have struggled to figure out what crypto is. Is it money? Is it property? Is it commodities? Is it a financial instrument? All the courts around the world have been having trouble on this. We don't have that problem. We do not have that problem because we wrote a constitution that said what it is, and we put it into our own court called ECAF. Now, you can go back to the courts and argue what it is. And you know what? For example, the US Secret Service went and seized all this Bitcoin from, what was it, Silk Road. What was the defense against that? They didn't need to argue about it because they held the keys and so forth. You know, you had to then argue, this is property, this is my property. And the court would look at that and say, well, prove that it's your property.
Yeah.
Where's your contract?
But the danger, I would say the danger is that we even try to define it for others. And that's where the danger is. I'm not going to define what it is for other people that have keys and access to these tokens. And once we do that, we're intervening in the very idea of a subjective matter. And if, you know, I wouldn't, that's not something I'd be interested in even touching.
So you would like the property to be subjective?
You know, however any other institution wants to define what it is, property, commodity, that's fine. It could you know, you could create a new definition for it, but to narrow the scope of it, you know, by declaration, by fiat, and saying it is what it is, and having unanimity about that is, I think, people, I would object to it. I'm sure at least maybe I would say the supermajority would probably object to that. So
the minority who have been robbed are of a different view.
It's true. But then robbed is also subjective, right? So I'll give you this example, right? The 2 million tokens, there was a recent case that there supposedly 2 million tokens were, I guess, either hacked or lost, right? You could take the other side, and to me, in game theory, you have to be careful of this, is what if there was collusion between the hacker and the hacked? The 2 million could be have gone to a friend with the intent that, hey, if we are going to reimburse with some kind of compensation fund those that have lost, where they could have done this on purpose. So now, how do you identify?
And this is being thought of by the arbitrators. The arbitrators,
which is like, again, it opens up the the subjective nature. It opens up for even more debate and dispute, I think. And so, you know, it's anyway. So I was thinking this in game theory. This is exactly the incentive for people to do this now. And that 2 million, I'm very skeptical of that. If you ask me personally, I actually think that there's a.
I mean, you're entitled to your skepticism, but you're
I'm
party
not.
to the case.
I'm not. But I'm just saying that more people. Yeah, it's an opinion, of course. But I think more and more people, game theoretically, will do this, and that's a major problem.
It's definitely a risk, which is why the CAF or the arbitrator conducts a certain amount of due diligence, goes through and collects their information. If you look at the orders that have been sent by ECAF to the block producers, some of them now include identity cards in them. So whoever's there has taken quite a risk. They've shown their face. They identified themselves. They put an identity card into the hands of the people. Is that enough? I think for 2 million, no. But
and then there can be in some jurisdictions there can be this tax dimension that you can write those down as lost, and then you could even in. I have understood that even in some jurisdictions you can get that deducted because that's lost venture. So
you get an extra benefit beyond just giving it to your friend and splitting the proceeds, and you get tax breaks as well. So anyway,
basically you can deduct all lost ventures.
Yeah.
So yeah, that can be a lost venture. So but unfortunately, guys, I have to go to Morrison's before it closes. Here we have a temporary apartment that I need to take care of, and yeah. So hello from Gibraltar, and good night.
Sounds good, Ville.
Yeah.
See you guys. Thank you.
Yeah.
Bye.
Thank you. So if anyone wants to join us as well, that'd be great. So let me see. I'm gonna. So sorry, I haven't been reading. So let's go to the side. Okay. Okay. What would Dan do if someone stole 1.5 million of his EOS? Whales rule the world. Greg Kirsch, judges with veto power, whales rule the chain, and top BPs. Whales are hidden judges with veto power. That's what Anna says. Through BPs that wish to keep position. RCs should hold the power. Recording contracts should hold the power.
They're static documents.
So,
just like orders from the arbitrator, they're not power until somebody grants them power.
okay, that's good. There's really, in terms of power, it doesn't. It's more about kind of let's say an expression of our statement of intent, I guess. Let me see. I think Dan mentioned this intent of code, recording contracts, proof of ID is needed for that to work well.
Well, yeah, a lot of the thinking is based on some sort of future identity system, and unfortunately, we don't have any detail on that, so it's difficult to evaluate. Now, the community is happy to take that option and work with that option for future delivery. But personally, I think we need to see a lot more detail. We need to see it working in practice. So we're probably looking at 6 months to a year before we get a good feeling for what this is.
I was hoping it was this week.
Before we start relying on. So I think what happened was Dan has presented some prototypes or something like that of biometrics on Apple gear. But
and it's only for Apple, huh? Do you think?
Well, last year he was working on just Apple. I don't know whether he's shifted across to working on others. Android does have the ability to store these things, but I don't know.
Okay, so theft is this is let's address theft though. So your I guess desires to have this Article 3 that deems tokens to become property, right? And by and following from that these are contracts between members, right? Whether it's I guess before it was considered a multi-party contract. So that's where I feel like, okay, if you, that's where I'm all for property rights or preventing theft, right? Especially if we have identity. But the idea that we could go from declaring something, which I would say is kind of that, most people are not going to even be signing up to anything as a contract. Really, it's even if you have these pop-ups most people don't read it, and it anyway. So there's a whole process that needs to be, I guess, executed to have someone be declared to have consented or accepted a contract. So aside from all of that, I think the main point is that if you kind of declare this, anything other than what people have claims to right now, and take any additional kind of authority over it, whether it's a definition or just to declare something, I think that's beyond what you would almost have to have unanimity for that. I think to be okay. Because everybody who participates in this probably has a different idea of what anybody can have claims to beyond like what people currently have, which is the keys to, private keys to an account that holds EOS, right? So,
well, you say unanimity, that's fine. I mean, we all have different ideas. And we all have different ideas about life and religion or trade or whatever it is. But when it comes down to it, when our ideas clash, how do we resolve that? We're in a dispute, and we either go to a dispute resolution forum or we start a war. The more advanced system is to go to dispute resolution because less of us die. So the question is, what are we going to do to resolve all of these different ideas? And when we go into a dispute, the tradition for any dispute resolution is to start with the documents. What are the documents? What did you agree? What was your viewpoint? Is it a website? Is it a FAQ? If you're talking about, say, an Ethereum thing, you're probably looking at a website and some vague claims in a Telegram list or something like that. If you're talking about EOS, we're talking about a constitution. We know where the constitution is. We know what it is. We're not arguing about the different constitutions. So it's very clear what the constitution is. And all you're really doing is you're coming up with this sense of, I didn't explicitly agree to that document, but I'm here in that space that is created by that document. It's not very strong.
Yeah.
It might be an idea that nobody has really considered, but when it comes to dispute resolution, we have to.
Yeah, and so I think you could get to a point where something like that works, and I think something at the DApp layer actually is a maybe because I'm not even discussing the efficiencies. I'm just talking about principle right now. The efficiencies are no whole other category we could probably discuss. Yeah, but I'm just talking about the principle, and you can have that. I think a system like that where rather than even making contractual, just make it so people agree to a broader legal framework that just considers restitution and civil manners rather than even dealing with contract law, and say that and people will understand that this is at least deemed as property in that jurisdiction, wherever you create a DApp that has all of this, right? So I think I support that. I support like a restitution, whatever it is. You could even extend beyond that, but just almost a new legal jurisdiction with that considers civil manner. That's civil manners beyond contract law, and so that's fine. To put it on the base layer where it's the most difficult to gain acceptance and informed consent about, rather than having the DApp layer where you can be explicit about this agreement, where it's this DApp's going to create this, and you have this button that you click. When we get to the base layer, people are going to create all these different projects. Most people aren't going to have Ricardians. Most people aren't going to do any, you know what I'm saying? So it's, there's a practical nature to that, but it's also, we can have all of this in the DApp layer, and I think people will be happy with that too. Just having that option where it's like,
No, they won't be
well, you disagree, but
no, they won't be happy with DApp layer. No. No, we know they won't be happy with DApp layer, because I'll tell you what happens with DApp layer arbitration. The DApps are big, powerful groups. The DApps are the powerful player. They will write their contract to suit themselves.
I think because this will be more important in this space than traditionally has been in just regular internet businesses. I think this will be more important. I think people will have a greater, I think they'll have a greater, they'll pay more attention to how they are.
I don't know how you could say that, because no other blockchain has done this. No other community has turned around and said this is more important. No user group is paying for more attention to contracts. The users do not read the contracts.
And I think it's the nature of why we need more, like this is what I would agree with. We need more arbitration in the blockchain world than in the internet world, because in the internet world, we actually live without much, any of these kind of arbitration systems, right? So and it's worked out, right? And so that would be an argument to say that the internet's worked okay without this kind of arbitration layer. But I would argue that the blockchain world has more value at stake, so that I agree there should be more arbitration. But I think naturally that will get people to pay more attention to these agreements because of the value that they're putting in the blockchain world rather than the internet world. So that I would grant, yeah. But I would still argue that the DApp layer, where you say there's control, I think it's just going to be competitive with a lot of DApps providing different user agreements and people deciding which ones they really like. And it's and I'm not even talking about like. To me, there's two arguments against it. To me, it's like giving the people the right to kind of determine what they feel this blockchain is all about, and taking the most conservative approach to that, right? Where code is law, there's a large significant segment that believe that, and then but you're inclusive to that, right? At least by eliminating arbitration at the base layer. And then you're open to everybody, that where people who believe in that will be happy, and then those that want what you want, where it's arbitration and a full legal framework. Maybe I like full legal frameworks on the DApp layer. Then I think everybody's very happy with that. Rather than if you do one like where you have arbitration on the base layer, you're going to have a significant group that's very, very unhappy, and then beyond that. Then I'll throw in the inefficiencies, but I don't even want to go to the inefficiencies. That's a huge.
That's another discussion. But just coming back to that, you say everybody's happy with code is law.
Not everybody.
I'll tell you who's happy with code is law: developers. Developers are happy with code is law, but developers don't pay salaries. Entrepreneurs pay salaries. Businesses pay salaries. Now, these guys are putting the code out, and they know that their developers are very happy with code of law. They also know their developers are very good at writing bug-filled code. And it doesn't matter how many times you tell a developer to write bug-free code, they won't do it. It's not in their heart. So what does a small business do? What does an entrepreneur do? If you write the DApp layer, you add arbitration, thief comes along and steals the lot, but the thief isn't under your jurisdiction, because the jurisdiction of the base layer is what has taken the value. So it's fine to go code is law. The point of EOS is that we're encouraging businesses to come in, entrepreneurs to come in, put in capital and build up a business. It's not encouraging developers. Ethereum showed that they could encourage lots of developers. What they couldn't do was encourage businesses.
Yeah, I think it's a broader, developers are a strong kind of contingent for code is law, but I think it's broader than that. I think the entrepreneurs also understand the power of having less subjective matters when it comes to business. It's more efficient, really.
I would say casino operators probably understand it. But even then, if you can get cacked, then casino operators are unhappy with code as law.
Yeah, and
because casino operators are a pure allocated game from left to right. You know, it's a very simple. It's just the machine. So yeah, code is law is fine for them. But for example, if you look at it, well, there are very few productive businesses out there. There's CryptoKitties and Steemit and things like that. Do they believe code is law? I'm not sure. Anyway, we're getting into the weeds here.
Okay, but yeah. So this is like kind of the interesting. So I think you make a good case, Ian. But I think the momentum. I think you're gonna have to go to all the channels because right now I'm pretty firmly.
Oh, I'm not going to convince any of you, except maybe Ray, who's typing away there. But the point I would make is actually we don't know. There are large communities out there that want this way and large communities that want that way. And until we get referenda, we have no idea. Or, we have our personal opinions. But really, this goes to referenda. And until we get that, we're not going to know where we're going.
Yeah, that's fair for sure. I mean, so there's a lot of token holders that are, we'll see, what, when the rubber meets the road, right? So I think that's great. We're about 1 hour 10. So I had a question for you, Ian, since you're here. You've created recording contracts, which is fantastic. I think that's what we're all here kind of using. Is embedded in the EOS system right now. I was thinking, in the Constitution, it would be good to have, and Justin has also mentioned as well here, to have the Constitution or articles in the Constitution be a recardian. I know you mentioned, it may make it a little bit more difficult for regular people to read, maybe. But I'm thinking that we should have the current parameters of the delegated proof of stake system written in the Constitution, so that if there are changes that want to be made, that you have something explicit that you're going to amend, and if it's a recording contract, that would be probably the most effective way of doing that, to explicitly have terms in the Constitution that says, however many votes however we have 21 block producers, have that as a parameter, right? That's a system contract, I'm sure. And if someone wants to say 25 block producers, that you have something specific that you're going to amend in the Constitution that says we're going to make it 25 or whatever. And then even compensation, that's another. So that is another thing that I feel like, and this is from the beginning, I was thinking, okay, if anything, I think, let's say whatever version, let's say, but V2 is what I was going to start with, as just adding just those articles that describe the current system via recording contract. So what are your thoughts about that?
Well, I think certainly I would agree that the Constitution should include those numbers which we're saying we all agree with initially, and we want referendum to change them. So something like the number of block producers, the percentage that is allocated to inflation, things like that are numbers that are very big touchstones for the community, or lightning rods for the community. So we should have those in the Constitution. I think as a practical matter, it was complicated for the coders to get that up and going in the time frame that they had. So consequently, there wasn't enough bandwidth to put in that parameterization. And I will say that, yeah, you're absolutely right. The parameterization is a really tricky one. Us programmers, we know how to write parameterization code. And lawyers know how to write prose. But mixing the two together is a little bit of an art. And so the book is not yet written on how to do this in the best possible way, such that the Constitution remains readable, but the parameters are easy to extract and are obvious to both the computer and to the human. So yeah, there's more work to be done there, I think.
Yeah, maybe we'll try to make an attempt at that, you know, just because, and then I'll read through all the recording contracts that exist in the system contract and elsewhere, just to see, maybe add a little bit more prose, as you know, than traditionally would be in, you know, in a regular recording.
Yeah, and we should remember that the lawyers will fill it up very quickly. And
yeah,
I would like to say that we should write our own contracts, and maybe just at the last step, have lawyers look at them and say, well, there's a gotcha here. Let's quickly fix that up. Because what we want is a contract that's readable by humans, not by lawyers. We want people to understand this and accept this and get with it. So in this sense, this whole proposal of new constitutions is a good process, because now people are forced to read these contracts and utter an opinion. They're forced to decide A or B. Whereas if you look at the normal process, you go onto eBay. Has anybody read the eBay contract? When was the last time you read the contract for a hire car? Whatever contracts you think you've accepted, have you really accepted them if you haven't read them? So, you know, let's get in there and debate this constitution, because at the end of it, we'll certainly have figured out what is our document, what is our constitution, what is our community.
Yeah, that sounds good. So I think that's great. Any other questions from the audience here, and then we can. And if someone wants to kind of join in on the chat as well, I think we're 1 hour 15 minutes in. I mean, I'm okay. I can talk for a little bit more. But any other questions about the Constitution? Thanks, Matt. Ian, any other?
I see Tanish is saying, please take ECAF to the DAP layer. We would love that. The problem with that is, if we do that, there's no enforcement for the Constitution. And if it's not enforced, it's just a guideline or a wish list. Or
you're talking to Tanish. He's got the bond system going. So that's where the enforcement, I think, is. That's pretty, you know, I'm looking forward to what he comes up with.
You need somebody to enforce. And then we're back to the BPs doing the enforcement. Well, if the BPs are doing the enforcement and the judgment, that's not going to last too long. It didn't last for STEAMIT. You know, STEAMIT is more or less.
Well, I think if you have a bond, the arbitrators actually can enforce at that point, right? Yeah.
Bonds. Yeah. The problem with that is that somebody's just been robbed of their life savings, and now you're asking them to double down and put more in.
Okay, so you're talking about, I think, so I think bonds is the initial step, and then you have insurance as a secondary step.
So everybody has to get insured? We now need an insurance contract in order to protect our rights,
Yeah, I mean, it's a...
You know, the Swiss will say yes. The Swiss would love that. They love insurance. But I don't know. I mean, there are lots of different ways. And fundamentally, I answer, if you've got that question of who gets to access dispute resolution in any particular moment, and it's controversial, then leave it to the arbitrator to figure out. Maybe there's a bond. Maybe there's an ECAF fee. Maybe there's some other thing. Maybe you need to escrow your daughter until the conclusion, which is, by the way, a system which is conducted in some countries. But the arbitrator can then look back, sit back and say, you know, in your case, no, we're not going to take a fee. Let's carry on. Or we send you back the fee. Or we get our legal defense fund to cover the fee, or something like that, if that is the case. Because, you know, humans can make judgment calls. That's why we use them.
Okay. You have a lot of trust in humans, Ian. At least
well, I've been in the computer world for 40 years. I don't have a lot of trust in computers.
Maybe it's the kind of, just...
yeah. But anyway, I don't want to dominate the conversation here. Oh, maybe I do, but why don't we...
Okay, so yeah, any other questions? And then I think we could wrap. Oh, there's the ask a question section. I don't know if we missed. Okay, so.
Oh.
Could V3 include an opt-in free market representation of arbitration for subjective matters on property like theft? You feel free, Ian.
Well, yeah, you can always opt into a different arbitration forum. The problem with theft is if you need the thief to opt in, he's not going to do that. So if you want to cover theft, you've got to have it compulsory 100% at the base layer. I'm afraid. Where are you
there's the ask a question section at the bottom. It's on the bottom right, I think.
Oh, yeah. Yeah.
Art of successful RCs. Yeah.
Is Materium an EOS arbitration service candidate? Yes, it is. But Materium is a commercial business and would need to do a deal with somebody. Now, they could, for example, potentially put in a WPS proposal. There was some thought of bringing them in the early days before mainnet launch, but that didn't work out. So I think, as a commercial operator, it's very difficult. If you look at, for example, Amy and her company SageWise, Amy's now running her working group, and she's having to put all this volunteer time in, which her company SageWise is having to pay for. And this is difficult because there isn't a clear proposal there on the ground which will pay her salary. So if you're looking at EOS arbitration, or if you're looking at one of these base layer things, there's always the question, who pays? Who pays?
Okay. So yeah.
A series on the art of successful Ricardian contracts with Ian. Yeah, it's an interesting comment. I would bow away from that for two reasons. I don't want to be I don't want to judge over Ricardian contracts and any particular Ricardian contracts too closely, because it's really up to the parties and the people to work with that. And the second reason is that although Ricardian contracts have been used a lot in technology, they have not yet done a lot in court. They've never been questioned seriously in court. They've been in court, but they've never been the crux of a court case. So it's hard to say. From a legal point of view, you would write about the court success of Ricardian contracts. But I suppose there is a lot of other stuff to talk about. Don't know. Think about that one. We are all volunteering our free time for free for over 6 months to EOS. Allow Amy to catch up. Yeah, it is hard. A lot of us have volunteered an awful lot of time.
I don't know who Amy is.
Amy's running the working group for dispute resolution and arbitration. Right. At the Alliance.
Yeah, I've been following that. I was just not thinking it. So.
Yeah.
Okay. So, all right, sounds good. Any last questions? And I don't know. And maybe. I don't know if someone wants to. I know Justin was there. Like, if he has any other comments. So you made a comment about doing. What is it?
He said trusting consensus amongst humans, but not in every one of them. Well, indeed, and this is quite controversial. Are arbitrators free agents? Should we just pick them, go into the street and round them up? No, I don't think so. The way ECAF works is it takes nominations. You have to be nominated by somebody else. And it will then go through this filtering process. It will talk to you, it will interview you. We'll take you through a few examples and see how it falls out. And what we're basically saying is this person got the right sort of mindset to take on the dispute of two parties and come to a reasonable decision over the future, the fortunes of these people. It's not an easy job. It's a very hard job, a very draining job, and it's the sort of thing where you really do have to be quite committed. And frankly, I'm not that committed. I would never be an arbitrator.
Okay. So okay, hey, do you have some more time? Ian, I could ask you some tough questions more on the efficiency side of arbitration too.
Tough questions. Love them. Bring
All right,
them on.
so ECAF has a bunch of cases right now, right? A lot of theft. So for the first question is, what are they doing with these theft cases right now? What's the status of those cases?
So I can't speak on any particular case. I don't know the situation with any particular case, but there is one thing that might not be apparent. They have decided, I think, as a standard, I'm not entirely sure about this, don't take my words to court, that there is like a 30-day waiting period in which to contact the counterparty who might be a thief or might be somebody who's on holiday. It hasn't really worked out that the claimant is the thief. So there's this period by which you have to wait and make sure you've done some efforts to contact these people. Another thing that's being done is that messages are being sent to the person's account. Money is being sent to the person's account, the alleged thief or the person who's got the value, saying, please contact us, so that all efforts are made. Then there is the question of due diligence over the people who are filing the claim, and that actually does take quite some time, many days. They want documentation, they want video interviews, they want this, they want that. So that could take a week or 2 weeks or something like that. So I don't think it's reasonable to expect any of those cases to resolve inside a month, and probably not inside 2 months. We're at a 3-month mark now. So yeah, maybe we should be seeing some results now, but the basic reality is that they are snowed under and they haven't got the capacity to push through these cases, and they are caught up in the queue of doing the emergency ones as a priority, which pushes back the resolution. So that's
okay.
An issue.
So the process, okay, that's in terms of efficiency. So how would it be resolved in your mind, those cases? Let's say we get some resolution, it is arbitrator decides that there's enough evidence. So what happens next in your mind? Let's say 3 months. 3 months.
Oh, if the arbitrator has enough evidence to conclude that there was a theft. So I don't think we've had that position yet, but I would say that if the funds had been successfully blocked, then an order would be prepared to move the funds back to the control of the declared owner. Now, the first thing that's going to happen then is, well, actually, we need to negotiate that with the block producers, in the sense that we can send them an order, but have they got the technical capability to do that, or how are they going to achieve that? So there needs to be a bit of to and fro to prepare an order that works for the block producers. So that'll take a bit of time. And once the format has been agreed, then other ones will follow on much more quickly. But for example, right now, nobody in the block producer world has ever sent money back, done a dodgy transaction that has reversed the course of a previous transaction. So we need to go through that process.
But what is your expectation? Because that's, again, that's probably going to make a lot of people probably angry if there's any kind of maybe reversal, right? Like the first reversal would be a huge PR kind of nightmare as well. But
absolutely, yeah, absolutely. But there will be a ruling laying out the evidence that has led to the conclusion that this money was stolen, and the arbitrator says this money was stolen. That becomes a fact at law. The ruling becomes facts at law. So if there's outcry over this, people are aghast at crime being stopped. That's very unusual. I mean, I understand that some people think that crime should go ahead because of various theories, but frankly, if we are protecting our blockchain from crime and people are opposed to that, I don't think we should spend much time defending ourselves from that
Generally,
process.
I think people will be fine, but again, all cases will be somewhat subjective. So the burden of the evidence is more, that's probably going to be a factor as well. So let's assume that this is agreed upon, and now a new transaction transfers the money back from the kind of the one account back to the former account. So those are cases where it hasn't been sold on exchanges, right? And now,
that's right. Yes. So you have to move the value back. You can't create new value. Well, in theory, an arbitrator could instruct the block producers to mint new value.
No, that's not what I'm saying.
In practice, I don't think that's really.
Yeah, that's not.
I don't think that's on the table.
So they do that. So how many of these cases are do we know that where it's maybe just sitting in an account that you can actually create a transaction to kind of pull back the funds, or perhaps they've gone to an exchange account where they've already been kind of
I think any value that has been staked and then started to unstake, I think a lot of those have been caught in time, but I don't know the numbers. Any value that wasn't staked, liquid EOS, is probably gone. Once it gets to the exchanges, then it's probably too hard to get rid of, to bring back. I mean, that's not entirely 100% true, because you can always reach out to the exchange and say a particular account is funded with stolen EOS, and the exchange might freeze that account on their behest. It might return the value. It might even have an insurance fund. I'm not saying this is happening much right now, but it has happened once. At least once, somebody reached out to an exchange and got the value returned.
Yeah. Okay. Yeah. So see, the exchanges. So that creates another issue, I guess. But let's say there's some resolution between exchanges and EOS, and aside from all the PR issues beyond that. So, but then going forward, let's say this is the process, so that you are now having to. Okay. First of all, liquid EOS is going to be much harder to resolve, just because you don't have 3 days, and assume maybe some of them have this 3 day staking. I don't know what percentage is what. Probably more will be unstaked, right? I would assume. Maybe not. I don't know. But so how does that? How do you do that as a blockchain that is running at like 2 minutes? Like, I mean, at every second, like every block, every second, like two blocks a second.
Well, humans can't do it. ECAF could potentially, not right now, but potentially they could get their average response down to a day. So ECAF can't respond in time. The block producers, as people, can't respond in time. The only way you could catch those sort of things is with automatics, with code. And then you've got to detect how it is that you're deciding that this is probably a theft and not an ordinary transfer. And that's what happened with the that 2 million or whatever it was, that big theft that happened 3 days ago. It was noticed that the key was replaced with another key, and then immediately after that, the unstaking process started. So Eric, who noticed this, then started reaching around and looking around, and he got confirmation because the victim had actually gone to EOS 911. So yeah, you could code that up. That part you could code up, and then you could spot it. You could red flag it, bring in humans to clarify. But we aren't saying that ECAF solves all crime. We aren't saying that EOS can stop all thievery. We're saying if we use the technology in a way that causes these barriers to slow things down, then we can decide to reverse that process if it's a thief.
Okay, so however, there's going to be fees, I'm sure, to prevent too much spam. But let's say there's, you're going to have hundreds and thousands of cases now where, I would expect of freezes now, right? Of accounts that are frozen because of potential theft, right? Or that, this particular account is right.
Yeah. There's no way human arbitration could deal with hundreds and thousands of these cases.
So what do you think will happen though once you
yeah.
have at least a significant number of freezes on the blockchain? I mean, just in general, what are your thoughts of the potential issues that
Well, I think it's going to put a lot of pressure. The community, that the block producers are going to be annoyed at the continual work, so they're going to put pressure on the developers to come up with automation for that process. And the developers are going to be thinking, well, you know, surely if we had these other things going on that would slow down the thievery, then we should do that as well. You know, block one, you know, this is what Dan has been working on to get it into hardware, trying to reduce the vulnerability to keys on ordinary laptops and so forth. If all of these things are in place, hardware escrow, multi-sig, 3-day delay for staking and so forth, if all of these things are in place, then it becomes much safer.
Yeah, and then no, that would be fantastic. And I think that's why I think Dan Larimer always kind of suggests that a lot of these technological solutions are actually coming out to help with this. And EOS Shield's another one that Anna mentions, which is a great a tool that
ECAF by itself can never scale, but ECAF with a whole bunch of other things can fill in that hole.
Okay. And then so this is Ray who says, hey, what about two chains? Code is law, and then code is law, but disputes are, you know, with ECAF and one without. So I think that's another option too. I mean, that's a possibility, right? So
yeah, it's a possibility, and to a large extent, it depends on the way the referendum goes. You know, I don't think there's any. You know, people are saying, "Well, we're surprised that it went this way," but actually, we've been talking about arbitration since forever. It was all part of the white papers and the introduction and so forth. So the problem there is people are surprised by one aspect of a very complex system. Is this good enough reason for those people to fork? Maybe we have two chains.
Yeah, and I'm actually fine with that. Really, in the end, I think. But I'm more like, again, like the reason why I support V2 is actually it's just more, it's closer to what we have in crypto. It's like the more conservative approach. I think if we go too far, it's a good experiment, and I think, but it's almost like you know, this crypto that has gained kind of the imagination of all these people. I mean, there's a reason why, and some of the reasons why are what we're kind of we're challenging, right? So that's why I feel like to be more conservative with this, and it's actually very like you're limiting the scope of what you have to focus on, and you know, people want to build, right? They want to just get started and build and things like that. So it's like once you add another layer, then you have a lot of work. I think it's a good experiment, and I would support you know, another chain that wanted to go full out. I think even Telos is going to have base layer arbitration. It's just an example. So maybe, you know, not the primary reason why you being conservative, because Telos is doing it, and just maybe you know, people could say, hey, we should be different, or but just in principle, just being conservative itself, I think is actually a good approach at this point, in my opinion, of course. And yeah,
your use of the word conservative is quite odd. I mean, most people will be conservative by using normal expected dispute resolution processes like arbitration, but you're saying looking like the other blockchains means you're
conservative to the traditions of blockchain.
The traditions of blockchains, which goes back 10 years and not a day more. You know,
and that's, you know, it's the same thing. Conservative in political terms are when you're conserving the traditions of a political system, right? And so I say blockchain, where you know, and most people are coming in from the blockchain world, and that's kind of what attracted people. So that's what I mean by conservative. But
yeah, but you know, they've also proven in blockchain that it's not a particularly good place to do business. So okay, let's try something different.
Yeah, I mean, I think there's but you know, it's you know, what are the reasons, right? And I think there are, I think that may be one, but you know, there's usability issues, there's scalability issues. I think Yeah, I think this is another thing. Then I'll point to why V2 is another thing to consider strongly on scalability, because and performance, because once you have a system where you're able to freeze accounts, to me that actually slows down a blockchain, right? The idea that you can efficiently just process all these transactions without this uncertainty, right? Well, you may.
Can you put some numbers on that? Can you show some statistics that EOS is being slowed down because of freezing accounts? We're running at 4,000 transactions per second at the moment. That's our the current floor. Ceiling, I should say. And we're probably doing one freeze every week, maybe.
Well, right now, and then it'll probably increase, I'm sure, if we have many different applications. We'll see. But I just so I think even having a process will, if you look at the highest level, the process and kind of this human intervention, naturally people will understand that is a kind of a slowing down of just overall transaction throughput, right? Could be for good reasons or bad, but I'm just saying. Yeah.
When the block producers execute a freeze order, all of them have to do it right now. They're devoting this new mechanism, which they're calling wrap, I think, today, which will allow them to automate that much more quickly. But yes, they have to do some work. Yes, that's right. On the other hand, we are looking at something like 3 million EOS under dispute at the moment. That's not chump change. That's worth a bit of work.
Yeah. And I think it's going to be difficult either way with that amount. So I mean, I don't, we'll see exactly what people feel, because there are a lot of people that lost EOS, and I totally feel for them. I do think that it's going to come down to referenda. I can argue till I'm blue in the face. You can argue until you're pink in the face. We're not going to get a resolution here in discussion. A lot of the people have made up their minds. I've made up my mind. You've made up your mind. We're not going to change each other's opinion. So fine. We're just going to have to duke it out in referenda. Yeah.
And we are in pain because we wrote the whole Constitution and the RDR saying, yes, we'll get referenda in there to ratify the Constitution and to elect the arbitrators. And guess what? We're still sitting here waiting for this step. And we've got this steady flood of people saying, but you're not part of the community. You're not being voted in. You're not this. You're not that. Please give us referenda.
Yeah. So it'll be interesting. And, it's going to be unfortunate either way. Like, there's going to be disappointed people, but I think that's just the reality of these big decisions. That it's you're not going to get unanimity, and it's just they're just going to have one side disappointed and putting a lot of effort, and but we'll see. But it really comes down to referenda. So
yeah. And, that's going to be a bit of a pitch battle, because the political sides are already lined up there and they feel that their cause is important. What happens in those circumstances? Well, you get political parties developing, you get politics, you get, dirty politics and so forth. So I hope we can conduct this in a civilized fashion and get in there and vote on the alternatives and keep it all together. But we shall see. Okay. We shall see.
Sounds good. And I don't know. Does anyone else have any question? Maybe just so that let's see. Feel free to pick any out, Ian.
What about the scalability of ECAF? Yeah, human arbitrators do not scale, but the alternative is systems like the eBay, PayPal automation system. And there are now a lot of systems around the world that do this automatic dispute resolution. However, they all require two things: experience with the nature of the arbitrations that are being conducted, or the nature of the disputes that are being conducted. And they require a body of cases which you can go through and establish patterns for. So we don't have either of those. We don't know enough about our disputes as they're coming in, and we don't have enough actual machine learning feedstock to be able to build up AIs and so forth to do this. The third problem is of course we need budget to build that. So part of the WPS process is about getting budget to build that, to either select suppliers like SageWise or Materia, or to start building it in-house, which is also an option, given that we have lots of programmers around who are very invested in this universe.
Where do you get those headphones?
So yes, scalability.
Justin's asking where you get your headphones.
These are called Parrots, but the problem is that they're all falling apart. The leather is very soft, and it's just they were nice and bright and orange 3 years ago.
I was thinking it was a fashion thing.
Wow.
All right. So yeah, that's great. I think there seems to be a lot of activity in China, working groups that are creating constitutions. I'll probably try to focus on just adding Ricardian and the current code in. That'll be my small contribution, I guess, if of course if people accept it. But I know Justin wanted to do that too, so if he wants to help, because I need someone else who knows the system contract.
Kanish asks a question: won't the thieves translating the tokens to dexes or exchanges? I mean, this is the case, yeah. However, the arbitration orders that are issued can be treated as general freeze orders. And if exchanges wish to play as nice actors in our ecosystem, there's no reason why they can't also follow those orders to BPs and take the accounts there and put them into their own blacklist. Same with the dexes. Of course, that's a politically sensitive proposal, but I make it knowing that in time, the exchanges and the dexes aren't that interested in getting involved in theft. As a big business owner, as an exchange operator, you would like the thieves to go away because they don't actually give you much ROI. They pay a few little fees, but they cause so much trouble by victims coming and banging on your door and being upset. So in the end, I think it's a better thing if you can take something solid like an arbitration order and say, oh yeah, okay, I'll just block all those, shove it into my own blacklist. That is a better result for the exchanges. So why can't they participate in blocking these accounts? That would be my proposal. And I think that will come in time. I think that's inevitable myself. Oh yeah. They won't keep their funds in exchanges. Of course, the game is the thieves have to move faster than the system, than the enforcement system. That's granted, and that's why we need that technical side as well. There's nothing perfect under the sun. People are still going to get robbed. The question is whether we can reduce that to a dull roar rather than a complete flood. So lots of fun. Designing a blockchain with such a large community is quite a challenge, and laying out the assumptions and building the bits in that you want it does kind of commit you up front, and it causes a lot of things to be different. There's not a blockchain out there where people are totally agreed on what it should look like. Every blockchain is surrounded by huge amounts of controversy. EOS is no different.
Maybe have only one main chain contract establishing code as law. I guess that would be V2, right, Eddie? Anna. Maybe
only have one main chain contract establishing V1, the current constitution. This is kind of the battle that goes on with, say, Bitcoin Core and Bitcoin Cash. Which is the true Bitcoin? Well, at one point after the fork, they were still exactly equivalent. They were the same thing. If EOS were to fork into the arbitration positive one and the arbitration negative one, or however you want to put it, then they're both the same until they start to differ. Where we have got an unresolved problem is who gets to use the brand name of EOS. That's
yeah, and I would say to that question, it'd just be based on the referendum, and if someone wants to kind of
the referendum on which chain?
Well, at least the current one.
That means we need a referendum to organize a fork.
Well, it would. I mean, the referendum, like the kind of the losing side of the referendum, if they so choose, can I would assume can do the fork. I would say. Yeah.
Ah, right. Yeah. So if the fork does in fact follow from the referendum, then that's possible. Yeah. Sure. That would be very civilized, and so far hasn't been a feature of prior forks.
The reason EOS.io work precisely because it can be modified and evolved as we test pivot, at least V2, V3. I was going to ask this, how are upgrades done on regular contracts? Is it just, you have a smart contract, you want to upgrade it?
You mean, well, on EOS, the contract, when it's posted, can be upgraded by the owner of the contract. They have an option of turning off on upgrade capability.
Okay.
Now, on Ethereum, there is no possibility of doing that. Any contract that's posted is set for life. And this is kind of where I think SageWise have built this kit, which you incorporate into your Ethereum contract. And that allows various upgrade capabilities. But that's automatically in EOS.
And you don't have, the BPs don't have to do anything additional to approve like an upgrade on any of these smart contracts?
Not on an ordinary contract, unless you've hit that button that says don't allow this to be upgraded. In which case now you're stuck. And then you would have to go to the BPs and say, I'm sorry. And they would turn around and say, give us an arbitration order. That's fine. So you'd now be back to the position of code is law, and you would have to go and get the arbitrations to allow an arbitration order to convince the BPs to do an upgrade.
Okay. So yeah, so no, that's good to know. Thanks for that. I just wanted to know kind of, because, there's going to be a lot of upgrades, which is good, but then also on the flip side, then you're going to have a lot of potential issues as well when it comes to bugs and disputes and whatnot, and I could imagine there's potential for some malicious activities, right, when you upgrade somehow. So anyways, and that of course is the whole thing about the conventional smart contract idea as per Ethereum and Bitcoin. The code cannot be upgraded, and therefore it's good as it is, hence this notion of code is law. But bugs, so we have to come to grips with how we're going to do that. And I think it's very early days. I don't think the winning solution has been found yet. Okay.
On the question, I see there's a lot of talk about EOS and EOS.io. EOS.io is a trademark of Block One, and it relates to their software. So anybody who's using EOS.io software could consider themselves to be in the EOS.io family, but they can't necessarily use that trademark. EOS as a trademark is kind of a public domain thing at this stage. It belongs, if you like, to the community. It's not claimed by any particular party to the extent that they can order anything about it. So there is a question with a fork as to who would get it. Exactly the same thing happened with Bitcoin.
All right, and we got about we got about 5 minutes. So it's this is the 2 hours kind of session. That's what we're limited to, and but yeah, we have 5 minutes, so we'll go to the end, I guess. So anybody else who has any questions, Just an FYI. Brendan Bloomer is on Bloomberg. It's good to know. That's good publicity. So any other questions? Might as well. I mean, we got we got Ian here. So anybody, any questions?
Well, I've never actually called into one of these things, so I just did it on the spur of the moment.
Okay.
You spotted me and dragged me in. I was just going to listen. I wasn't doing anything. Hybrid V3 contract. Well, I think talking about versions is a complete misnomer. Everything past the current one is a proposal. I think the issue is how we move forward, and there's obviously big camps for the the V2 proposal and the current constitution. But I think probably what we really need to do is to think about one that brings everybody together, and that is going to be a process of working through the things that are on the table and writing a complete new one. And I would say we should have a constitutional convention, bring the people who are interested in this process, have a lot of input into it, and lock them in a room for a week until they come out with an agreed constitution and propose that to the community as being representative of everything that's there. Now, this would be a big event. I think we should probably bring in people from the entire world, definitely from the Korea, China, Singapore, also a few from Latin America, North America, and try and get people to go through a process of saying, we can work with this. We can. What's the biggest part? What's the biggest consensus we can reach? As a group of experts or self-interested experts, we self-nominate ourselves as experts. And then with that document and dozens of people having consensus over it, start a process of selling it to the community. That's what I think should be done. I think that would be a better result than one person sitting down and writing a contract and trying to present it to the rest of the world as if that one person has the lock on wisdom and knowledge and so forth about constitutions.
So yeah, that'd be interesting if we could get something together. It seems like we're getting close to the point where we can start creating, different versions, or just I think we in the EOS Alliance meetings we've gone through, I think, both constitutions already, and the study group we've gone through both in general. So. But anyway, so we're probably at that point, which is good. I was thinking it was going to take a lot longer. So, yeah.
One of the good things is that each of the clauses, for the most part, the clauses in the Constitution and the proposed one are isolated from each other. So it's possible to, say, I want to talk about clause 1 and you want to talk about clause 3. Put people in different rooms and come up with these perfect clauses or agreed consensus clauses, having discussed it and debated it. There are some gotchas, though. There are some clauses which interfere with each other. And if you carefully look at that, the constitutions and the proposals, there are some that actually conflict, and they have to be carefully thought about as well, which is going to be a harder job.
Yeah. And then version 2 has, a lot of articles that overlap with version 1. I think it's essentially the first 2 articles, which is kind of the difference, with intent of code is law. And then the articles 3 through 9 it's a variation of version 1, essentially.
Yeah. So I think what you would need to do is go through a process where we would say, look, clauses 1 through 15 have these titles, and they draw from these related clauses from other proposals. But let's just agree on the titles, and then we stick the people in a room and say, come back with the best clause for that. So there's a preliminary step. Let's agree what the titles are of each clause and line them up and number them. Sure.
All right, just a couple minutes left. It'll count down, and then it'll probably, stop 2 minutes after the the 2-hour mark, and we're like a minute left. So I mean, it's up to you. I mean, we can. Any last questions, I guess, until we just get kicked out here.
Justin wants to define key terms. So here's a question: do we invite the lawyers to the Constitutional Conference?
Yeah, everyone's invited, right? we're all inclusive.
Aha, that's an answer. Yeah. That's a good answer. And it says no. See, we're already at war.
No, but so
yeah. Ray says yes. Yeah, maybe this needs to be a poll.
So
everyone has to have a voice. I mean, I agree with that.